York courtroom, you can almost feel the power snap as Judge Merchan shreds Trump's immunity shield in real time. Gasps, chaos, total meltdown at the defense table, and then the president himself in a humiliated walkout as his last big legal cover-up is exposed. This was supposed to be his fortress. Instead, you're watching the walls fall and his whole strategy collapse on live TV. A stake case he can't pardon, a legal invasion he can't spin, and a sense of betrayal that cuts straight through American democracy. Stay tuned, because this is where the truth finally hits.
We're hearing from President-elect Donald Trump's team following a new ruling in his New York criminal trial. Judge Juan Merchan has rejected Trump's attempt to have his case thrown out. His attorneys have pointed to the Supreme Court's July decision on presidential immunity, but Merchan says the case concerns entirely unofficial conduct. CBS News correspondent Caitlin Huey-Burns is now in West Palm Beach, Florida, and joins us live to talk about it. Good to see you, Caitlin.
Hey, Vlad. Well, this was a very interesting case because, as you mentioned, this centers around the question of presidential immunity, which was established by the Supreme Court earlier this year. The Trump team was trying to argue that evidence collected through this.
They told us a president could never really be held to the same rules as everyone else. Tonight, a New York judge just proved them wrong in a way that Trump's team clearly never saw coming. In a packed Manhattan courtroom, Donald Trump's lawyers walked in acting like the word immunity was some kind of magic shield. They tried to wrap that word around everything he did, before, during, and after the presidency. And Judge Juan Merchan took that shield, snapped it in half, and then, almost calmly, set a criminal trial date anyway. Not for some tough policy call, not for a controversial executive order, for a secret payoff scheme to hide an alleged affair from voters, right as they were deciding who should sit in the Oval Office. Let's slow this down and walk through it clearly, because the details matter. Earlier this year, the Supreme Court handed down a big ruling about presidential immunity. Republicans and the MAGA media celebrated like it was a blanket get-out-of-jail-free card. But if you actually read what the court said, it wasn't that at all. The court drew a very specific line. Presidents get some protection for official acts, things they do as part of the job. But anything that's personal, political, or unofficial is not covered. No shield, no special bubble. Trump's lawyers looked at that narrow legal lane and tried to drive a semi-truck through it.
But he did say that he wants to keep the polio vaccine. And I should mention, too, that when Kennedy arrived on Capitol Hill yesterday to start his meetings with senators, he also said he would like to keep the polio vaccine. Vlad?
Yeah, I saw that moment with Kennedy shouting that out to reporters yesterday, Caitlin, and it just sort of reminds me of the Senate and its role for advising and consenting, that you see this play out with Supreme Court nominees, right? They get up there and they say, oh, nothing that I said in the public record has anything to do with how I'm going to, decide cases if I should be put on the bench. I hope that in this particular case, because Robert F. Kennedy Jr., as you know, sued to have the polio vaccine taken out of schools in years past. So we'll see how it all breaks down. But I think a lot of...
They came into this hush money case arguing that because Trump later became president, somehow the things he did around the 2016 election should be treated as intertwined with his official duties. That because he eventually sat behind the resolute desk, hiding damaging information from voters magically becomes part of the job. They tried to blur the line the Supreme Court drew between official and unofficial conduct until it basically disappeared. Merchan said absolutely not. He didn't invent a new standard. He took the Supreme Court's own framework and applied it to the actual facts in front of him. Step one, what's the conduct? Secret payments routed through Michael Cohen to silence Stormy Daniels. Falsified business records disguising what those reimbursements really were. All of this happening before Trump ever took the oath of office. Step two, what was the purpose? Not to defend the country, not to carry out foreign policy. The purpose was simple. Keep voters from hearing a damaging story that could hurt his chances on Election Day. That is classic campaign conduct, and very personal campaign conduct at that. It has nothing to do with the constitutional duties of the presidency. It has everything to do with Trump, the candidate, protecting Trump, the brand. So Merchan did what judges are supposed to do. He called it what it is, unofficial, personal behavior. And under the Supreme Court's own rules, that means no immunity. And you could see in real time how devastating that was for Trump's team. Reporters inside the courtroom described the reaction. Gasps at the defense table. Lawyers who've been doing this for decades, staring at the bench with that look of, wait, did we just lose everything? This wasn't a routine setback. This was the collapse of the central strategy they'd been clinging to for months. Because let's be honest, immunity wasn't just one argument in a long list for Trump. It was the plan. Delay everything. Wrap every case in a big, vague claim that the president can't be prosecuted. Try to keep evidence out. Try to shut down trials before they start. Hope that the combination of legal fog and political power would prevent any jury from ever hearing the full story. Merchan took that plan and ripped it up. You said the hush money scheme is exactly what it looks like, personal conduct. He said the Supreme Court's ruling doesn't give Trump a special force field around his campaign. He refused to treat the presidency like a retroactive cleanup crew for bad behavior. And then he went one step further. He set a trial date, December 2025. Let that sink in. We are now on track for something the country has never seen. A sitting president in a New York courtroom as a criminal defendant facing charges tied to an election he already won. Not as a witness, not as a background figure, as the person in the defendant's chair while the rest of the world watches. The logistics alone are staggering. Secret Service details navigating courthouse security, motorcades pulling up at a building where everyday New Yorkers report for jury duty, cameras outside capturing the president walking in, not to give a speech or sign a bill, but to hear testimony about falsified records and secret checks. And behind all of that theater is a deeper, quieter question. Do we actually believe in the rule of law? Or is that just a slogan we repeat until someone powerful enough decides it no longer applies? Because this ruling, this one decision about immunity, is about more than Trump. It's about whether the presidency is a public trust or a sanctuary for personal misconduct. If we say a president can't be prosecuted for stuff like this, what we're really saying is, once you win once, you're untouchable. Everything you did to get there is forgiven, no matter how deceptive or corrupt it was, as long as you can connect it to politics. That's not democracy. That's monarchy in a baseball cap. Now, Trump's lawyers are going to appeal. You know that. They're going to run to higher courts. They're going to ask for emergency stays. They're going to go on TV and talk about unprecedented persecution and weaponization. The talking points are already written, but here's what they can't escape: the legal pattern that's been forming over the last few years. In case after case, courts have been rejecting Trump's broad immunity claims. Federal judges have said no. You can't just declare yourself immune from prosecution because the events touched politics. Appeals courts have reminded everyone that the presidency is powerful, but it's not an invisible cloak you can wrap around criminal conduct. Even the Supreme Court, in a decision that many of us felt went way too far in protecting presidents, still carved out that crucial category of unofficial acts that can absolutely be prosecuted. Merchan simply followed that line, and in doing so, he sent a message that echoes beyond this one courtroom. If you use money and secrecy to manipulate what voters know, you don't get to hide behind the title president forever. The other piece here that scares Trump's team is the nature of this case. This is not federal. This is New York State. And that matters because the ultimate nuclear option, the presidential pardon, is off the table. No president, not even Trump himself, can erase a state conviction with the stroke of a pen. If a New York jury convicts him and a New York judge sentences him, the only people with any say over that are in New York, not in Washington. So when you hear people shrug and say, he'll just pardon himself, understand, not here, not in this case. That's one reason they were pushing so hard on immunity. It was the only true escape hatch they had left. Think about what it says that a president of the United States is fighting this brutally over whether a jury should even be allowed to hear evidence about secret payments and fake records. If you were confident you did nothing wrong, you'd want your day in court. You'd want to clear your name. Instead, the strategy has been delay, 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 and redraw the map of presidential power so that criminal law simply doesn't apply at the top. This is where the stakes get bigger than Trump. If his version of immunity wins, every future president sees that playbook. You don't just run for office. You run for legal invincibility. Anything you do that touches politics, including lies, cover-ups, pressure campaigns, suddenly becomes part of the job and therefore untouchable. The office becomes not a responsibility, but a shield. Merchan's ruling pushes back on that in a very specific way. It says, no, you don't get to turn election manipulation into official business. If you falsify records, if you secretly pay people off to keep voters in the dark, that's not governing, that's cheating, and you can be prosecuted for it like anyone else. Now, does that mean the system is perfect? No. Even now, Trump is benefiting from layers of delay, deferential treatment, and political calculation that an ordinary defendant would never see. But this moment shows that the system hasn't completely surrendered. There are still judges willing to look a president in the eye, figuratively and literally, and say, the law applies to you too. And that matters for us as citizens. Because when you strip away the legal jargon, this case goes to the heart of whether our votes actually mean something. If a candidate can quietly buy silence, bury damaging stories, and then later claim that the whole operation is wrapped in presidential privilege, our right to make informed choices becomes a joke. The ballot becomes theater. The real decisions happen in hotel rooms and back channels, and the courts are told they're not allowed to ask questions. By rejecting immunity here, Merchan is saying voters deserved the truth in 2016. They didn't get it. And the fact that Trump later became president doesn't erase that. It actually makes it more important that we confront it. That's why December 2025 is such a critical date. It's not just the hush money trial. It's a live test of whether we mean what we say when we talk about checks and balances. Can the judicial branch actually check the executive, even when that executive is sitting in the White House right now? Can 12 ordinary people, drawn from the community, look at the evidence and reach a verdict without being overruled by political power? Those are enormous questions. They're uncomfortable. Authoritarian movements don't like those questions because the whole point of an authoritarian project is to make one man's will more important than any law, any institution, any jury. You hear it in the rhetoric. I alone can fix it. Only I can save the country. And underneath that is the silent add-on. And therefore, I shouldn't have to answer to anyone. That's the through line here. The fight between rule of law and the idea of a leader who stands above it. We've seen this tension before in American history. Nixon tried to claim that if the president does it, it's not illegal. The courts shut that down and forced him to hand over the tapes. Clinton tried to argue that a civil lawsuit should wait until after his presidency. The Supreme Court said no, the legal process can continue. Again and again, when presidents have tried to place themselves on a different plane from everyone else, the judiciary has had to step in and say, you're powerful, but you're not sacred. Trump's immunity strategy is that same instinct turned up to 11 and extending into the criminal realm. Not just, I shouldn't be distracted by lawsuits, but I shouldn't be prosecuted at all. Merchan's decision brings us back toward the older, healthier idea that presidents are citizens too. So where does this leave us? We're heading into a stretch where the President of the United States will juggle governing, campaigning, and appearing as a criminal defendant in a state case that he cannot simply make vanish, The evidence we've only heard described in filings and reporting will be laid out under oath. Witnesses will be cross-examined. Jurors will sit, listen, and decide, and the rest of us will have to decide something too. Whether we still care that the rules apply to everyone, or whether we've grown so numb that even this doesn't move us. If we still care about democracy, if we still believe that no one is supposed to be above the law, then this moment isn't just about Trump's potential guilt or innocence on specific counts. It's about defending the idea that truth, evidence, and accountability still matter, even when they're terribly inconvenient for the man in power. The immunity shield that Trump's lawyers tried to stretch over everything has been cut back down to size. Official acts get some protection. Personal schemes do not. It's a simple line, but it's doing heavy lifting for the Republic right now. And that's why, years from now, we may look back on this ruling as more than a footnote in one case. We may see it as the moment where the legal walls stopped moving backward and finally started holding firm, not just against one man, but against a broader attempt to turn the presidency into a throne. For now, what we know is this: the trial is coming, the excuses are running out, and for the first time in a long time, it's not crazy to say that accountability at the very top of American power isn't just possible, it's already underway.